All right, welcome everybody to our webinar called Creating Strong Design Protection. This webinar is recorded just as a information for everybody joining in. So if you do not wish to be heard or seen in this webinar recording, then please keep your mics and cameras off. But otherwise, you're warmly welcome to Ornamo and BEDA's webinar on intellectual property rights for designers. And today we're going to take a deep dive into design protection and how to make that strong as possible. A few other housekeeping matters before we get started on the subject matter today. The chat is open for questions throughout this whole webinar. So if you have any questions that come to mind, please write those into chat. We will have time for discussions and comments at the latter part of this webinar. At that point, we very much welcome you to also open your mics and cameras to ask your questions yourselves if you want, but you can send the questions at any point during this webinar. And another last housekeeping matter is that after this webinar, we will send a very short form feedback survey, just asking if this webinar and its content was useful to you and worth your time. And we collect this information for our funder, EUIPO, and this information helps us to determine whether this type of webinars are useful in the future as well. So very much would like to ask you all to take 2 minutes to answer that survey. But yeah, this today's subject matter, creating strong design protection. We will discuss this topic with the help of two fantastic experts. And I think before I start my bird-eyed overview on intellectual property questions pertaining to design and designers, I would like to give the floor to our expert guests, Katri, Kiviniemi and Andreea, Bende. If you could shortly introduce yourselves and tell a little bit of what you currently do.
Okay, we go in the order of presentation. So hello and good afternoon, everyone. My name is Katri Kiviniemi. I'm a European trademark and design attorney, as well as authorized Finnish trademark and design attorney. I've just spent the last 2 years, surprisingly, in Norway, outside of EU, working there as a design and trademark attorney, and just recently returned to Finland to work in a general business law firm called Katri at Snellman in Helsinki, which is the oldest firm actually in Finland, but luckily not the stuffiest one. Happy to be back here and happy to be here today to give you this presentation. Thank you.
Good afternoon, everyone. Thank you for joining us today. My name is Andreea Bende. I am a trademark and design attorney, also practicing before the EUIPO. I've been involved in this field since 2005. Sorry, time flies. I'm based in Eastern Europe, more specifically in Transylvania. And I am a partner leading the intellectual property practice of Pacu & Partners, who is a Romanian full services law firm. Thank you very much.
Thank you both very much for introducing yourself, and we will hear more both from Katri and Andreea in just a little bit. And I will get started on my presentation for today. Just a second, I will get it on the... Yes, while we get the presentation up. Yes, okay. Now it at least shows on my screen that it is visible. So yeah, just a few words about who we are as organizers of this this webinar. So my name is Iiris Adenius. I work as a lawyer at Ornamo, and Ornamo is also a very old organization. We were founded in 1911, and we are the second oldest design association in the world, and we currently represent over 3,000 individual designers in Finland. And our purpose is to advance designers in their career and promote the role of design in society. And to accomplish our purpose, we provide several different kinds of services for designers, and you can find our members on our online platform called Finnish Designers. So if you're interested in who our members are, we have a great platform there, and very much also encourage our members to add their professional portfolios into our Finnish Designers platform. And today we're discussing intellectual property rights, which is a very important part of designers' work and designers' rights, as part of a project that we're doing together with BEDA, the Bureau of European Design Associations, which is kind of like an umbrella organization for over 50 European design organizations and associations. And we are cooperating on this project called Design as a Competitive Edge, which is funded by EUIPO, so the European Union Intellectual Property Office. And the purpose of this whole project that we're currently working on is to empower designers and also design-driven small and medium-sized enterprises to really utilize their full potential of their work with the help of intellectual property rights, and that is what we will dive into today. Yeah, and just as an little peek to what's coming up next. So today we start this webinar series with the subject of creating strong design protection, and then we will discuss licensing specifically and enforcement, battling IP infringement, especially in an online environment in October. And then last on the 5th of November, we have the last of the webinar series concerning the new design legislation that's upcoming and how that will affect designers in Europe especially. But yes, today we will discuss design protection. But before we go into the specifics of that, I will give a very general and short overview of intellectual properties from a general bird's eye view, especially from a designer's perspective. So first of all, please excuse my very simplified description of design process here. So just to kind of start with the very basics and understand where we're coming from, this is to describe just the typical situation where a designer starts. So with an idea or concept, whether that's from users to market or a specific customer, that the need for a new product or service comes from. It first only exists as these ideas and concepts, and based on those ideas, a more specific model is created. And in this example, I'm using a light fixture as an example. And then after the model has been created, that model can be turned into an actual physical product in this example and then sold to customers. But then from the customer's point of view, let's say that this customer very much wants to buy a product from this specific designer and this specific design, but sometimes that job gets a bit more difficult when the market has other products that some of them may look more or less like the product that the designer has created. So from the customer's point of view, how can they decide and distinguish which of these light fixtures in this example actually come from this designer? And from the designer's point of view, how can they actually be able to be the ones commercializing and selling their product and prevent others from creating similar or the same designs and selling those themselves in the market. So just a few words about what are intellectual property rights in general. So first of all, it's good to understand that these are based on legislation that is territorial or national. So it's good to understand that there's always some kind of a policy behind it and some kind of purpose for each piece of legislation. And as with all the rest of legislation, there's typically different kind of incentives behind a legislative act, and it's a balancing act of finding the right balance of different, sometimes contradicting, opposing goals. So intellectual property legislation typically wants to incentivize innovation and creativity and the investment it takes to innovate new products and services in society. One thing that's kind of good and interesting to notice is that intellectual property rights go hand in hand with sustainability goals many times, since it kind of only makes sense to invest in intellectual property rights if you have planned for your life cycle for your product or service to be kind of long enough to sustain the IP protection investment as well. But as we kind of go more into what do these different rights give us, it's just good to remember that there are different kind of goals, and one of the goals as well is to have fairly free working competition in the market as well. And then when we look at what do these different laws actually grant the owners, there's typically this exclusive right and this exclusive right to commercially use that this certain type of intellectual property. And in practice, that means this right to prohibit, which then pertains to these enforcement issues that we will discuss today, and then also later in October in the third webinar of this series. But it's good to understand that these exclusive rights, there's always the kind of line, where do you draw? How long of an exclusive right do you get? What is kind of considered inside the circle of exclusive rights, and what's kind of goes over it? And another important aspect to understand about intellectual property rights as an umbrella term is that it is divided into two main categories, one being copyrights and the other being industrial rights. And some of the typical ways to protect design products, for example, is with designs, trademarks, and patents and utility models as well. Now, this is a bit more of what it looks like to look at these issues from a designer's perspective. So typically when there's a product in this example, there are certain aspects of the product that the designer or the company utilizing the design views as creating their unique competitive edge. And for example, in this specific example, there are a couple aspects, or there's like the usability of the product, the aesthetics, and the sustainability. For example, the sustainable manufacturing process that's used to create this product, and also the whole life cycle of the product. And then this is all tied together with the brand and the kind of brand value and brand promise that this
Recording in progress.
Okay, we have. Let's see, we have some voice problems here, but just continuing in a little bit. Okay. All right. Let's see. Now I think we have a bit of a better situation. Sorry about that. But yeah, so in this example, we have a product that has certain aspects that have been used as its competitive edge. And then you can look at each individual aspect here. So let's say, for example, the usability. What is actually that creates the usability? Is it a technical solution, which you could then potentially protect with a patent or utility model? Is it part of the appearance of the product? Is there a design aspect that could be protected with a design, for example? And the other example, what is it exactly that creates the aesthetic appeal of the product? Is there a certain kind of pattern that's used? Is there one part of the product that kind of stands out that could be then protected? And again, we have different ways to protect that same product. So just to show you a bit more of a designer's way of looking at these protection questions. All right. Yes. And then let's go to this more typical legal way of looking at the same question. So the same product, design product that can be protected with different forms of intellectual property rights. And then again, we can look at the individual aspects that can be protected with each different type of legislation. And as a kind of last point on this, just showing you a couple of comparative things about these different forms of intellectual property rights. We won't go too much into details in these things, but we can see that all of these different types of intellectual property rights grant exclusive rights that are more specifically determined in each of these legal acts. And then we see that there's different requirements for getting the rights, and also the time of the exclusive right is different for each different type of right. And then just taking a peek view on what do you do with this intellectual property rights? How do you use them? So in this example that I showed you first, in the direct sale situation, if you manufactured your products yourself, maybe you didn't need intellectual property rights yet, but as soon as you outsource the manufacturing, you're actually granting somebody the right to your intellectual property rights. And if you have somebody else, for example, resell your products. And also quite typically in design field, you can license both manufacturing and reselling to somebody else, or even just transfer all the rights to a third party. And in all of these situations, and especially if you're commercializing your product yourself, then monitoring and enforcing your rights is an important aspect of intellectual property rights as well. And again, just reminding that we will discuss these other aspects of designers' intellectual property rights further in these upcoming webinars. And just to highlight here that this is the bird-eye view to intellectual property rights from a single design product's point of view. And today we are focusing on design. And kind of as a last point on this, just to remind you that these certainly are not mutually exclusive rights, but actually studies show that the strongest protection for a product is created with a combination of these different types of intellectual property rights. So that is certainly good to remember, that it doesn't have to at least be which one to choose, but how to combine these in a smart and efficient way. And as my absolute last slide, I just want to remind you that as of 2 days ago, the SME fund on EUIPO's SME fund that actually gives financial support to small and medium-sized enterprises in Europe and in EU to protect their rights, and even to just figuring out what kind of rights they might have. So you can get direct financial support for that from EUIPO's SME fund. So make sure to check that out. The funds will most likely be out soon again. So now is a good time to apply. But without further ado, we're going to jump into today's topic, design protection, and I'm really glad to give the floor to Katri Kiviniemi at this point.
Fantastic. Thank you, Iiris. This was a very, very nice introduction to both of our presentations with Iiris, I think. I will now do the most challenging task of the presentation. So I'm going to try to share my screen. Let's see how this will work. Please inform me when you see it.
Yes.
Do you see my screen? Yes, I can see Andrea's thumb going up. Fantastic. I had a short introduction already, so I've been working as an attorney for quite a while, like my lovely colleague from Romania, Andreea, has as well. In addition to being attorneys, we two are actually colleagues by another association, which is called, of course, acronym ECTA, which comes from the words European Trademark Communities Association. And although it contains trademarks in the word, we also have committees that I am actually chairing right now for designs. Andreea is one of the very, very active members of the said committee. And we worked together with several other lawyers from around Europe and also from around the world that work in either private practice or in companies that have their own IP departments, and also within academia. So we all come together and discuss topical IP matters, as well as we have the tendency of giving advice and kind of working together to the benefit of our clients with the offices like the EUIPO and also like the World Intellectual Property Organization, WIPO, and of course with the legislatures. As Iiris already mentioned, and you have an upcoming webinar coming later on this year, there is a design law reform going on in the European Union. And although the current law is very good, at least from my perspective, it still needs some updating. So it's not by no means fantastic and ready for this technological age that we live in. But anyway, it is a fantastic piece of legislation, and we're hoping that it will come into fruition at least at the end of 2025, hopefully even sooner. That was all about ECTA. And we do also at ECTA have the goal, as I think that Ornamo, BEDA and EUIPO as well, that we would like to get more companies to realize the value of intellectual property rights in general, and also the value of design rights especially, because I think that from all of the IP rights that Iiris very kindly introduced us into, design rights are maybe the less used and also maybe the less known of industrial rights like trademarks and patents, and also in relation to copyright. I think copyright, trademark, patent is something that many companies consider, but design rights may be something that they do not, at least at the outset, consider. And also I think it's actually for some designers also a bit unfamiliar. They tend to think, and correct me if I'm wrong today, but they tend to think that why to do that, because I already have copyright. And we will tell you today why to do that, actually. And let's hope that you will be convinced after our presentations with Andreea. Before diving into the actual presentation, I need to make a disclaimer. Of course, we are lawyers, we need to disclaim things, so sorry for this. This presentation is not legal advice as such. Also, all the views and opinions that I may, or as my lovely colleague Andreea knows, I will give some opinions, definitely, are mine and solely mine, not of ECTA and not of Katri and Snellman. And also I am claiming all the mistakes and errors that there also may be in my presentation. And after this, sorry, long talk, we will move to the actual presentation. So what to expect from the presentation today? Both me and Andreea, we have a long experience. Andreea has plus 20 years. I have sadly already plus 25 years. So we've seen the legislations change, society change, and as I mentioned, the technologies changed a lot already. And there are things coming up and also been bubbling under already for decades, like 3D printing, which is now coming more and more everyday thing for people to use at home as well. And also the AI is a very prominent thing leading up to even to let me say to legal issues. It's been used a lot, although it's been debated a lot that should it be actually used in the actual legal work. But I think it's coming to us and is already integrated into our world and into our systems. So what do I go for with this longer introduction is that the world is not getting simpler. As Iiris already told you, the best protection is usually using all the possible tools that you have, maybe IP tools, maybe other legal tools, maybe contracts, something else that would support actually your business better than the intellectual property rights. That may also happen. But I'm thinking still that this technological, let's say, a rush of things with the AI and other measures, I think it's good for all of us. And I think that in terms of intellectual property rights especially, I think that the offices that we currently work with a lot, and probably you also file applications in by yourselves, the EUIPO and the EUIPO, have done a great job in creating very good technical platforms, very nice user interfaces. They're very intuitive, or maybe you can, as designers, also give them pointers if you think they are not intuitive, but at least from our attorney's point of view, they seem to be very nicely developed and very easy to use. So what we are not going to tell you today is how to use those user interfaces, because you might be aware that the offices have very good tools, they have very good tutorials, nice introductions, and as I said, they have the administrative knowledge about how to use their programs and their filing systems in the most efficient way. Of course, Andreea and I, we do it also on a daily basis, but it's like 5 to 10% of the work that we actually do with designs. And why do I say it's only 5 to 10% of the work we do? And what we are going to talk to you about today is the work that we do with our clients before the actual small amount of design filing and after. And I will claim that the value of your design registration, it comes from the work that you do before and from the work that is actually done post registration. So I'm not saying that that the registration itself is completely redundant, but I would like to say that it's more important the decisions that you make from the business point of view than the actual process of registering. And as said, it is pretty easy nowadays. So we are going to concentrate today on the things that you would need to consider pre and post filing, as we like to say, in a bit fancier way. So this is a good question, isn't it? What is the actual value of your design? This is a question that I pose to my clients on a regular basis, actually, when we discuss that whether they should or they shouldn't file for design protection. And I find it that every time it's a bit surprising. I think, what do you mean by value? What do you mean? We value our design. It's an artistic design. It's a good design. It's a fantastic design. It's my creation. I'm proud of it. And everything and all those answers are very true and valid. But when you are trying to convince people around you, the markets, the commercial side around you, of the fact that your design has value, how do you show that? How do you show to an investor that your design actually has value? That is something that then in these discussions comes up. They are like, okay, what is actual value? Okay. Let's look at this from the point of view of business and IP strategy. Obviously, you know your business. If you're a designer or if you have a small company doing product design, it doesn't actually matter. If you're a designer, the design is obviously the core of your business. And if you are a designer that has a company that does product design, I would like to claim that the design is also in the core of your business. So what are you actually willing to risk in your business? I think that these considerations are the things that you would need to consider whether to file for design registration. Let's take a few examples. If you're a designer and you have this fantastic design and you go to a company and offer it for the company that, hey, I've made this design, would you like to manufacture it? I could license it for you or give it to you and we could make a deal or something. And you do it before you have actually registered the design. Unfortunately, sometimes the world is very, very cruel and dog-eat-dog world. So it might just happen that the company says that, yes, thank you, we would love to meet you and see your design. And then what happens after that meeting is that they said, no, we're not really interested, or this is too expensive, or something is wrong with the product. And after a while, you notice that, okay, they have come to the markets with very, very similar, if not identical product. My question to the designers at this point in time is, how do you prove that you have the design first? How do you prove these things? And now you say it, okay, as I mentioned, there are also other legal elements or measures that you can take into the equation, not just registered rights or intellectual property rights. You can have a contract. You say, okay, I had an NDA when I went in. It's a good thing to have an NDA, but you also need to enforce the NDA. So if the company that has actually signed the NDA, they break it, you need to take them to court. So it's not inexpensive to do these things. It's to be mindful, and in my mind, at least to have the registration in place already before you go into these kind of negotiations is just simple, like good practice, so to say. I would say that going into these situations without any coverage is not a business that actually is viable or is sensible to do. it's a question that what you are willing to risk. Of course, if you have a good cooperation with the company, you've been working together for years and you have established connections and you know that you can trust them. But in this world, do you really know who you can trust? Maybe in the sphere of Finland or in a small market somewhere else, you could do that still, but I am still a bit doubtful of that, especially thinking about the things that I have also seen at my desk while doing this work, the advisory work. I would suggest you to register before showing the product to anyone, except of course for lawyers, because we are covered, so to say. Yes. What about the small company? The small company ends up with the kind of same situation, maybe being more directly to the markets. You design something very nice and then someone picks it up from the internet, let's say. They copy your product and then they offer it for sale to Temu. What happens? Temu takes it on and they sell it for 50% less that you are, or 80% less, thinking about the prices of Temu. And then when the actual product looks like your product and Temu's quality may be questionable, at least in some products, then they come to you and complain about the quality of the product because the product is almost identical and they think that it's actually your product that is faulty. Think about the harm it will do for your company's reputation and for the product's reputation. Do you want to end up in a situation like that? I'm thinking that most of you are now thinking that no, and that doesn't actually happen, but it actually happens. So I think that these are some of the very, very real things that you should be considering when you think that, should I register or should I not register? What am I willing to risk? So that is the thing. On resources, obviously, if your answer to the previous question is that we don't want to risk it, and I think that then you need to consider the next steps. And what the next steps can be, they can be that you contact your lawyer in your association, like Iiris, and say, Iiris, I've done this and this and this, or you contact offices, or you try to find out the information by yourself. I think that that's absolutely allowed, and it's smart to have some kind of understanding of these things yourself. But taking your valuable time and using it to something that someone actually does better, that doesn't make any sense to me. I wouldn't want to design my own shoes or do anything of that sort. I couldn't even, but that's not the point. The point is that I wouldn't do that. Even though with 3D printing, it might be more affordable or even easy for me to do, I still wouldn't do that, because something goes wrong and you have no guarantee and you don't know what's happening in the product. You don't know if the materials are safe, and there are a whole lot of things for me to consider that I wouldn't understand that the designer understands. You see where I'm going to? There is a reason why Andreea and myself are professionals in this field, because we have the experience and we know the laws. In addition to that, we don't just know the laws of our own jurisdictions. We know a whole lot of other lawyers from other jurisdictions that we work together with. So in nowadays, in the market situation that we are in, it's seldom enough to just sell for the European market or even Finnish market or Romanian market or Swedish market or German market or Estonian market, whatever market you're in. They are usually quite small markets. You want to go international, obviously, with your product, or hopefully you want to do that because then it gives you more revenue. But anyway, in that sense, when you think about it, the time and the resources that you are willing to put in, usually I think that it pays off to use the professionals for the things that you do not know, or you have questions about, or you want to just like explore or think that, what could I do? I think that there are a certain or a fairly big amount of people that might think that advisory services are kind of fluff, that they do not they do not get value for you. You don't get value for your money of the advisory services. But I think that if you think of the cost of the time that you use to kind of try to get the same information or get the same basic information that we have as professionals, you can get to a certain level. And as I said, it's very good to get to a certain level so that you understand what we talk about when we talk with you. But to get all the knowledge and all the professional knowledge that we have from back years, I think that I think it's worth to pay for, so to say. And I hope that you will agree with me, as I am agreeing with you, that I cannot be a designer or make beautiful or even ugly products for that matter. But it's obviously your choice, the time and the costs. What do I mean by that design right is not a price for a good design? This is also something that I usually discuss with my clients. And the bottom line is that you can, of course, file a design protection for at least for anything in those countries where the offices don't examine the design rights when you file them. So there are two types of offices that you may have encountered. There are those offices like the US office that they actually examine your application. They check for the prior art, so for the designs that have been filed for you, kind of similar designs. And there you have to be very, very careful, or let's say extra careful when you file. And then there are offices like the EUIPO who say that they are registration offices. So what you register is actually on you. You need to be savvy about what you register, that it's actually a design that affords a registration. I will go into that a bit further in my presentation. And also you would need to be careful about not infringing other people's rights. So those rights that are already been registered and have the exclusive right. And in addition to that, you would kind of need to position yourself into the markets in a way that is sensible for you. And when I say that's sensible for you, you need to get some kind of understandable form of your assets. So I'm going back to where I started from when I discussed with you that how do you value your design? Does anyone else see the value of your design, and how do you make it visible, let's say, for the commercial world or for the investors? So not a price for a good design, but it is actually a valuable commercial asset for you when you get the design registration. But as such, I would say it doesn't have any value, or if it does have some value, the value is minimal. What can be protected as a design? I'm going very quickly through this. Iiris, I think that you had in your presentation the requirements for design protection. So there are a whole lot of requirements for design protection, but there are two that are very crucial, essential requirements. And even though the laws differ from country to country, as also Iiris mentioned, or from a geographical area to another, I would say that these two requirements are kind of the same. Some of the legislations in the US or in Asia, they might have a bit of a different term or a bit of a different interpretation of the terms, but they still are quite the same. And these two criteria you saw already on Iiris's presentation. The first one was novelty, and the second one was individual character. I think that in Iiris's presentation said new, and that is the same thing as the novelty requirement. I trust that you have read about this, but I'm still going to go through them because they are very crucial in understanding some of the important points of creating a strong design protection. So novelty means that do not publish your design before registering it. So your design has to be new. It cannot be published. It cannot be disclosed if you want to register it as a design or it cannot be launched, it cannot be partially launched, it cannot be sent to a newspaper, it cannot be put on an internet site, or even in a printed paper if you wish that it will still be new when you file for it. And then, as this is the law, there are, of course, some exceptions. These exceptions are not in all around the world. These exceptions are only in European countries and some other countries outside of European Union, and of course EEA countries like Norway and Switzerland. But if you publish your design before filing it, obviously this has been created that you could kind of try the product in the market and see if it flies or not, and see if it's worth to put the few €100 in. But I would say that what happens immediately after you publish your design is that you lose part of your international market, just like that. You put it online and you lose most of Asia. You cannot protect the design in Asia anymore because they have the requirement of absolute novelty. And that is not a good standpoint to be in. And that's why I always say that the filing in the grace period, so to say, after publication, is a fallback position, that it should only be used if you messed up, if you by accident did show your design somewhere and then kind of had to quickly file it before it got big or huge in the markets. And this is not just small designers who do that. This is big companies that do this as well. So I think that it's very important for us to learn from the mistakes that some people have made and thereby understand the system better and not do the actual same mistake. The other thing that happens immediately when you have a good design and you put it out to the market, it can nowadays be big in few seconds, like it goes out there, and I hope that you have experienced it. But anyway, if your design is very attractive, it might happen that it gets instantly copied. And how do you at that point show that the design was yours? Or let's say it gets worse. Someone sees your design, and in the European Union, as the office doesn't examine the design, it goes straight in, that someone else gets the design protection for your design. So they go in and they see your design and they get a design protection for it. It's not very often this happens, but I've seen it happen. And even though they are in bad faith, obviously, which is a term that means that it's wrongdoing, they were not in good faith. It's not a good business practice, obviously, to do that. But what do you need to do after that? You need to show that you had the design first. You need to go to court and claim a better right to the design. But yet again, you will need to do something that is more expensive than actually the filing of the design. And I hope that you will never encounter this kind of behavior in the markets, but let's say it's not that unusual that you would think it happens as well. I'm going to take a bit of a pause here of those two requirements. So you now remember that the first requirement was novelty. But I'm going to take a leap and talk to you about priority, because priority is something that is related actually to the filing strategy and to the filing of the first design application that you do. So if you're smart enough that you have a novel product and you do not publish it, you go straight in and you file it, let's say in the EU. Priority means it comes from an international treaty called Paris Convention. So it's convention priority, actually. They have, I think that they have all 180 member states, so almost all the countries in the world are in this treaty, and all respect that. So when you file the first application in the European Union, say, and then you think that, okay, I would actually need to file this also in Japan. From the first filing date, you have time, 6 months, to file the application in Japan. And what happens during that 6 months, you can claim the same filing date as the first application had. And what does that mean? That means that your application within that 6 months still gets priority over those applications that are filed in Japan. So if someone files the same design or similar design, something happens in between, it may be that your design has the better priority over that design. So this is something that you might want to use, and this is kind of a very short break from the requirements, but just to remind you that this was a simplified example, that you file one application first and then you file second then and stuff like that. You need to, when you file the first application, think about which countries do you want to cover, where do you want to go, and kind of the strategy from the very basic application point of view to get adequate protection for your design, not just in the European Union, that you have good enough application and good enough registration that you can actually out wide to the world, so to say, to bring it forward to the Asian countries, maybe even North American markets, and so on and so forth. But this is something that you need to remember, that there is a possibility after the first application to use the priority to get the same filing date and actually get the priority in that country for your design. We can take some questions about this. I think this is pushing too much information for you. Let's go to the second very important requirement. So novelty, no publication, please, at least from my point of view. I'm very strict about that. I'm not very happy about the fallback position because it cuts out most of the international markets. The second one is individual character, and this is as well a bit hard to explain, but the EU law says that design has an individual character when the overall impression it gives to an informed user differs from these previous designs, putting it very bluntly. So putting it even more bluntly is that the design should be different, at least to some aspects, from the designs that are already in the markets. So this is it. It has to be new, do not publish, and do not register designs that are identical or similar with the ones that are already in the markets. So putting it very, very simply, so to say. What else? What can be protected as a design? Let's say that you want to protect your design even if it's not new and it's not individual. You can do that. And you can see examples of those kind of designs also in the EU registry. And it's because the EUIPO does not examine the applications that come in. It would be impossible to know all the designs in the world and examine all the designs in the Europe even. So what needs to be done is if you wish to get rid of a registration, if someone is sending you a warning letters that you're infringing my design and we have a design registration, and you think that, okay, this is something that I do not think that was new or individual at that point in time, or other things that the advisory people can explain you, then you can go for an invalidity action. I think that the system, how it works in the EU, is that everyone files a lot of designs, and then they try to use them for different kind of purposes. But if they try to enforce them, so to use their right to get some leverage in the market, get some room in the market, so that you could say to the competitors, you can do this design. I think that these kind of registrations are very bad for that purpose, and I think it's also very expensive, or rather expensive, to try to prove that some registration was actually, or the design in the registration was actually in the markets before the one that sent you the letter actually registered the design. So it can be done, and you can also do it, but I would not recommend to do that because it just causes confusion. It's not good business practice. And a design registration as such, if it's not novel, if it's not new, and if it doesn't have individual character, it has very little value to you. I think I might run out of time quite quickly, but let's look at the important part of the presentation. So how do the designs actually look like in the registers? I have tried here, this is a slide that I have been using for years already, and I have tried here to depict the same that Iiris did with her beautiful linear presentation. I have tried to depict here from the left to the right the designs that could be trademarks, also trademarks. These are designs, registered designs in different offices. These could also be copyrights or trademarks. As you can see, there are a whole lot of logos, there are labels, there are user interfaces and stuff like that. And then in the middle, this is more like the core design point of view, those CAD drawings, the car, the watches, the speaker, and also the kind of like general product shape, and actually more like product shape, not necessarily logos or graphics like you can protect also with copyright or with trademarks. And then when you go to the right side of the screen, you see the more kind of patent type, very technical type designs that have been registered with a lot of details. I'm not saying that all of these details could stand the test of the design being valid, but I'm saying that they are registered, or at the time when I took them to this presentation, they at least were registered designs. They might have been invalidated after that or not renewed or something like that, but as it was at the time when I took them, they were registered. Here you can see kind of, oh, sorry. Now I did something funny and, oh, yes. Yes, I was about to say that here you might want to consider two things. The first thing is that, as you can see, there are a whole lot of different things that you can actually protect as a design. So everything from logos to mechanical equipment, and that can be done. And the second thing is, from the point of view of a strong design protection, is that let's see that how differently these designs have been represented in the register. There are like very, very simple line drawings, very technical things. Then there are CAD drawings, and then there are colorful things. There are partial designs, and they have been depicted in different ways. And this is something that comes from national legislations. There are countries that have different kind of requirements. And also this actually is a consideration that you need to take based on the product that you have. It's not good for all of the products that are in the markets to depict them or represent them in line drawings. It might destroy the actual scope of protection they have if you don't see the colors, or the other way around. That line drawings wouldn't be a good way to show, let's say, graphical user interfaces. So here you can also see the complexity in terms of the styles of representations that you can use. And let me be clear, and I think that Andreea has very good examples of this as well, that it will inflect the kind of possibilities to even enforce the design, and of course that the kind of possibilities you have to use or can use the design depending on the jurisdiction you're in, so the country you're in, because of the differences in the legislations. I think here it's very good to pause for a while as well and say the fact that design protection is a protection that gives you only protection for what you see. So what you see is what you get. I have only in this slide taken up the first picture or the first view of the design. You might know that the designs can have several views and several pictures depicting the design from different angles or different colors or something happening in the design in general. But anyway, the design gives you protection. to exactly what you see in the registration. So that is why it is very important to think about how do you put in the registration. And there are some countries that have some requirements pertaining to the amount of views that you have to have of the design. But in countries like Europe and US, you can actually choose the amount, and you can also play that as a strategical card. If you don't show everything, you don't claim everything, you just claim parts. And there are a lot of things that you can actually do with the representations, and it's very important to be very savvy about that, what you do when you do it. I'm almost through my lecture today. Let's go back to the beginning, obviously. So how do I do it? Do I make or buy? As I already said in the beginning, it's obviously up to you how much time and effort do you want to use in registering your design and doing the work, especially doing the work before that. But I would say that it's always good in life to have a clear goal or a strategy, even more so in business. Do your research and do prepare. It's never wrong to be savvy yourself, to be knowledgeable of the possibilities you have. And my advice for everyone in the field is that do not publish your design. If you're thinking about registering your design, do not publish it. And I'm saying here as well, Andreea will tell you about the options. You do not have to, and it's not maybe suitable not for every occasion, for every design, to get a registered design. But I would say, as Iiris said, that is the best form of protection for design is to get a registered design. Not forgetting that there are also other options. Ask for help. Call Iiris. Call EUIPO. Call the Finnish office. Call the Romanian office. Call advisory. Call someone and ask for help. And be prepared to listen. Be prepared to change your mind if you're set on that I want to register a design and your advisor says to you, not really worth it, or should we consider some other options or things. Be prepared to change your mind. And then to the filing strategy, as I was already explaining to you through the pictures of the designs that I showed you. The filing strategy is actually the thing that you need to decide when you file the first application. What kind of product do you have? Is it a partial design, whole design? What type of representations I want to use? Do I want to use CADs? Do I want to use line drawings? Is this suitable for this and this and this market? And okay, what do we want to do? And in these kind of discussions, I think it's very good to have a knowledgeable partner, a partner that knows design law and knows kind of also the international sphere of design law. And then comes the easy, nice part that you can do also by yourself with the office. Design attorneys like my colleague Andreea and I, we do it of course for the clients, but we tend to do more advisory work than the actual filing work. So you can do it by yourself. But do remember that before you do it, take contact to someone else and think about your strategy. Do not publish and be savvy about what your business is about. If your business is about design, I would say protect your design before someone takes it from you. Then we end up with the registration, which is obviously happy days. Congrats. But I will remind you that this is only in the countries that have the registration system, as I told you before. So in the countries that examine designs, the end result might be something else than registration. It might be a refusal, that you do not get the protection that you have sought. So be prepared for that outside of Europe, at least. But if you're happy enough to get the registration, is it the end? By no means. And on this point, I will give the floor to Andreea, who will give you the post-filing part of these considerations and how do you get a strong design. And I think that if you do not have the time to pose your questions today, you can easily contact Iiris, who has our contact information, or you can contact me directly, especially pertaining to this presentation and anything that I have said today that raised some thoughts or questions. Thank you for my part for now.
Thank you, Katri. Good afternoon. Thank you for giving me the floor. I hope my presentation is on screen for everybody and that you can see it. Okay, thank you, Iris, for the hands up. Yes, registration is definitely not the end. It's in some ways just the beginning of enjoying your design, exploiting it, and taking advantage of what you have created. And moving forward from what my colleagues said, from the overview of IP rights that can be protected by you, from the importance of creating well-thought strategy in the terms of pre-filing, I wanted to give you some more information about registered and unregistered rights, because although I agree very much with what Katri said in terms of do not publish, just so you make sure that you keep your options open for every international region that you might want to tackle. You do have an option of disclosing your design and still maintaining some rights. And this comes to the first part of my presentation, which deals with very different types of protection, because in addition to registered designs, and all the things that you see on screen are registered designs, which I have identified in the EUIPO database. So these are just examples of things that you can register from a multitude of options in terms of what you can create. You also have the possibility of claiming unregistered rights. And the EU legislation, the Community Design Regulation, gives you this possibility of claiming unregistered community designs. Now, as opposed to the registered design, which grants you protection for a period of 25 years maximum, the unregistered designs are seen as a short form protection. Because they are only protected for a term of 3 years, and this is calculated from when you actually, from when the design is first made available to the public in the territory of EU. So if you cannot listen to us and you publish after all, please be aware that if this has occurred, you still have some sort of form of protection as a non-registered community design, which is added to, of course, your copyrights and other rights associated to your work. So this is something to have in mind, and I think it's specifically important for fast-moving industries where maybe you have large volumes of works created. I'm thinking here of the fashion industry, where maybe you launch fashion shows 2-3 times per year, and maybe it's difficult to not disclose something, and maybe it's difficult to protect everything as a registered design. But then you can use this option of unregistered community designs to test the market, let's say, to see if your creation is marketable, is publicly attractive, and then beware of the 1-year grace period in which you have the option of also filing for a registered community design. So the law gives this opportunity, and disclosure by the applicant would not destroy your novelty as long as you are aware of this 1-year grace period. Now, how can we prove this disclosure that I'm talking about? There are various options that are not limitative provided for in the law. I'm thinking here maybe you participate of a fair or an international exhibition with your design that occurs within the EU territory. Maybe you send a mass publicity, maybe you send it in a newsletter to a trade association. There are various things that you can do to ensure that you can prove the date of disclosure properly. However, given that are several limitations to these unregistered design rights, we always recommend that you also file for a proper registration when the design becomes interesting for your business, for your marketing strategy, and for further exploitation. Speaking of disclosure, I tried in this part of my presentation to discuss about some common mistakes that are not necessarily post-registration, but also pre-registration. I'm sure that Katri will agree with me that these are things that we've seen quite often in our practice, and we would like not to encounter them as much as we do. And the first one deals with disclosure. So as Katri was saying, do not publish. But if you do, make sure that you publish it with purpose and that this publication works for the interests of your business. And here I have selected an example that you as designers or maybe practitioners in this field have. I'm sure you have either heard of it or maybe remember it. It's been quite largely discussed in our groups. It deals with a community design registration for protecting the images that you see on the left screen, the numbered images. It was a design protecting the image of a Puma shoe, which was obtained in 2016. And then 3 years later, a third party sought to challenge it, to cancel it, claiming that it should be invalidated because it was disclosed by the applicant and therefore it was not new. So in proving this argument, the party challenging this registration put forward various examples from social media where this image of this product image, so this design, had been published by Rihanna 2 years before it was filed for registration, in which she was promoting her new position as a marketing and creative director for Puma. Of course, because this disclosure occurs 2 years prior to filing for protection for the design, it was deemed to be sufficient for canceling this registration. So this example shows us that disclosure is extremely important. And although, as I was saying, an applicant is permitted to disclose its own design to the public without immediately invalidating its novelty, this disclosure needs to happen during the 12-month prior to filing. As this was not the case, unfortunately, it had an undesired outcome for Puma. So you must be vigilant with all disclosures. Again, I'm thinking of the fashion industry where maybe your designs are not mass-produced already, but maybe you give them as gifts to influencers, various celebrities to use them, I don't know, to wear them at a fashion event somewhere. You have to be aware that these might end up online, on social media, everywhere in the press, and then you have to be attentive to the date when this happens, so you make sure that if you want to register that specific creation, you then file for registration immediately. Now, moving forward from the moment of disclosure, another aspect that was also touched upon by my colleague Katri was the importance of graphic representations and filing for, because as she said, what you see is what you get, and the scope of protection of whatever you decide to register will be defined by this graphic representation. There is not much that we can enforce outside of these representations. So in my next example, I will shortly discuss a case where the graphic representations were not aligned with how the design was actually marketed. In this example, which deals with, once again, a community registered design that you see on the left, was protected in black and white per the images on screen. Now, at a certain point in time, somebody decided to challenge this design registration in response to an infringement claim. So the owner was trying to enforce this design against a third party that was copying it. And the other party defended by claiming that the design resulted from a technical functionality and therefore it shouldn't have been protected. Now, in defending against these claims, the design owner, on the one hand, showed that they had protected various other design variants and showed that because of this wide range of design variants available, this specific design appearance was not linked to a technical functionality. But at the same time, he argued that the design had a two-part color configuration, which he claimed to be apparent from the design's graphic representation, allowing for a two-color appearance that was not dictated by the technical functionality of the product. The product deals with a packaging device. So this case was dealt with by the German courts, who decided to send a referral to the ECJ and asked for a preliminary ruling. And one of the questions that were referred to the European Court of Justice was whether this two-color part combination should be taken into assessment when dealing with the technical functionality of the product if it was not part of the graphic representations for which the design was filed. And as you can imagine, in short, the court answer was no, you don't have to take into account this unless it results from the graphic representations on file. So the conclusion here, or the thing to take home, is be very attentive for what you file, for what representations you file protection, because they may become extremely relevant when you want to enforce your design or when you want to defend it against somebody challenging its registration. And there's not much you can do once it was registered for limited graphic representations or only for insufficient views of the design. It will be its registrability or its enforceability will be analyzed based on this. Now, because in this example we talked about technical functionality, and we've seen in practice quite a few times clients saying, oh, I didn't file for design protection because my creation is fully functional, it's too functional, it cannot be protected as a design. Yes, in some instances this may be true, but then there are situations where it is not. There are situations where even if it deals with a functional product, the design of it, the exterior appearance, the aesthetic appearance can still be protected. And this is the case of my next example. It deals with a skin brush that was protected by L'Oreal and then enforced in the UK against a competitor that had designed and was marketing a quasi-similar product. Now, despite the fact that this community registered design deals with a rather functional product, in this case, the court looked at the degree of the author's freedom. Now, this is a very important concept that we deal with when we deal with design conflicts and the extent of protection offered by a registered design, because when the author creating this design enjoys a wide scope of enjoys a wider freedom, then it means that another design that copies its aesthetical elements is much more obvious to represent an infringement. The differences can be only minor differences, and then infringement is very often established. So in this particular case, even if it dealt with two designs that were linked to something that was functional, because the product at issue gave an overall impression that was almost identical to the one protected, it was sufficient to be regarded as an infringement. So drawing from the above, when you are not sure whether your design is too functional or cannot be protected, ask for help, as Katri said. Get some advice. Maybe somebody will help you decide otherwise, and maybe you will realize that your design, even if functional, it can still enjoy protection through registration. Now, drawing from the examples that I've mentioned, they also dealt quite substantially with design variants. And this is also something to have in mind. When you create design variants, make sure that you also protect them through registration, because everything is evolving, design is evolving, and so it's registration. Sometimes it's not sufficient to register a first version of your design and then 5 years later, I'm sorry, you might realize that you have added so many new elements in the aesthetic appearance that it's that they become sufficient for making a new registration for this evolved product. And this also applies to consumable product parts, which may evolve themselves alongside the main product which they relate, but which they can be once again subject to design registration. I'm sorry. Now, since we looked at the most common mistakes that we encounter in practice, there is one that happens also post-registration. It deals with renewing your design protection. Now, I mentioned that design is valid for 25 years in the EU, but this is not automatic. You have to remember to renew it so that you can enjoy for the protection for the entire duration of these 25 years. You would be surprised about how many times in practice we were asked to enforce a design that had elapsed in the meantime. And then, of course, we do our best to claim copyrights. And although we can still do that, you still have copyrights over your work. There are quite some limitations in terms of arguing for copyrights alone. And even if both legislation and case law recognizes the cumulative protection of designs and copyright, there are quite a lot of issues here that you encounter in practice in terms of what the argument you put forward, especially for those types of designs that don't have an obvious artistic value, let's say. And things are much more difficult in practice when you want to enforce copyright alone for something that was already protected as a design but elapsed. So therefore, I cannot stress this enough. If you registered your design, you were successful in this process, do not forget about it. Do not forget to renew it when it's time. Now, once you secured your registration and you have your certificate in hand, which, as Katri mentioned, in some jurisdictions can be more difficult than in others. Romania is also a jurisdiction that has an in-depth examination of designs. So we have even third-party opposition procedures for designs. And it's much more difficult and time-consuming to obtain a registration. But then choose the EUIPO. I always tell my clients, go to the EUIPO. The process is extremely fast. It's very easy. The application works perfectly. The fees are where they should be. So you have other options. But when you are successful and you have your certificate in hand, this is just the beginning of the process, because now comes the hard work, in my view. Now comes your role in monitoring, in marketing your design, first of all, yes, in exploiting it. But in addition to this, you have to monitor the market. You have to monitor your competition, and the more successful your design is, the more prone to copying it will become. So the more attentive you have to be on what's going on the market. And in addition to monitoring competition, we've seen in practice that infringements can come not only from your competitors, but sometimes maybe from your affiliated entities, maybe sometimes from your business relationships, from your resellers, from your manufacturers, from your licensees, so from your importers, and so on. You have to be very attentive, and you have to make sure that in the agreements that you put in place with these entities, you have an IP clause that it's strong. Ask for help if you don't know how to draft this. it's important that it's written in a way in which you ensure that the party who you are contracting with is aware of your rights, assumes an undertaking to respect these rights, to use them properly as per the conditions imposed from your end as the holder of the design registration, and then include some obligations for situations in which they do not do that. In a way that you are protected for the duration of your business relationship with this party. Now, once or if you encounter an infringement on the market, take prompt action against infringers. Now, this may sound like something complicated, especially if you have a very successful design and it's largely copied. This does not necessarily translate into going to court immediately. This may mean taking action by sending a warning letter, sending a cease and desist letter, and asking them to stop what they are doing. Make sure that in the letter you clearly explain what you are invoking, what are your rights, and what you are asking them to do. Explain why their actions are actually infringing your designs, why your rights are exclusive, and why the product that they are putting out, copying your design, constitutes an infringement. And by means of this letter, you can also claim some damages if you have some information that will allow you to make a calculation of this sort. You can also claim compensation for the legal fees that maybe you incurred in sending the letter if you asked assistance from an attorney or a counsel. Of course, it's not 100% sure that you will receive the desired result by taking this route. But in some cases, in most cases, at least, is sending a message to the market, first of all, that you are actively monitoring infringements and that you are prepared to take action, even if you're not. But at least this is the message that you are sending with these letters. And in some cases, you will be surprised about people's reaction, because some infringers can occur accidentally, and then they might decide to take you upon your request and stop. And this will save you time, it will save you money for going to court, and you will end up at the end of the day with the knowledge that you have taken all the necessary steps for protecting your exclusive rights. Now, of course, when this is not successful, you need to take matters. You have to decide whether you want to take the matter further into court. You can, of course, put in balance here pursuing a court claim, whether filing a criminal complaint or going to a civil court and also asking for damages. The effort and investment into this action needs to be put in balance with the infringement that you have identified. Maybe it's a one occurrence that you can tolerate, maybe it's not, but once again, make sure to monitor third parties' activities and copies and infringements that are on the market, because the more you tolerate, the more they will expand. So it is always recommendable to take some kind of actions against infringers. And another thing that you can do once you obtain your registration is apply for customs protection. Now, this is something that we recommend to all our clients, but specifically to those that have some knowledge or some information about suspected products or infringing products entering the EU from abroad. You have the option of filing an EU customs application. It doesn't involve any official fees. And after filing it and assuming that it was filed properly and accepted, your rights will be protected at EU borders. You can also file national customs application. We have a lot, because I'm from Romania, and Romania is a point of entry in the EU for quite a large volume of infringing products coming from China and mostly Turkey. We see a lot of national applications, and In such cases, my recommendation is always to provide customs inspectors with as much information as possible that you have, because maybe you have some information and some knowledge about companies that are involved in transportation of suspicious goods. Maybe you have encountered these situations in the past. Maybe you know some customs offices where these types of products normally enter the EU, things like that. And of course, information crucial about your product in which your design is transposed. So this will enable inspectors to take more efficient steps in protecting your rights at the border. And by doing this, you make sure that these products will not reach the market channels, and thus making your life a bit easier in terms of enforcing your rights. These are just some of the things, or the most important things that you need to be aware of and look at post-registration. Of course, they may seem a lot, like in addition to the stress of gathering all the information and your strategy and all your ducks in a row before filing, then more work comes after registration. And I realize this is not necessarily the message that we want to transmit. Be aware that your creation is valuable, and the more effort you put into protecting it, registering it, enforcing it, the more valuable it becomes. And then the more marketable it will be for you or your company, and of course your business partners. And something to take home: when in doubt, ask for help. Go to the EUIPO, go to Ornamo, go to EUIPO, go to your local IP office. All of them, or for sure most of them, have relevant information on their websites, have guidelines, have manuals that you can read, can offer assistance in terms of how to file. And you are not alone in this. We are here to help all of us. Thank you very much.
Yes, thank you both so much for your wonderful presentations. And yeah, now we have some time and opportunity for discussion. So if anybody in the audience would like to take the opportunity to ask questions from the experts in the field, and yes, we at least have Katerina is raising her hand.
Hello, can you hear me?
Yes.
Thank you very much for the lecture. It was very useful. So as far I heard like several lectures like that, and it's always mainly concerns industrial design, and well, it's kind of very clear. But I would like to hear more about like design crafts and something that relates more like a bit closer to art and the things which have much more variables and which are more about like ideas, which is usually said that ideas are not protected. And so that kind of work is usually heavily relies on ethics, which quite often are non-existent. So what's your advice on strategy dealing with this kind of stuff, on things which are quite often like said not to be protected? And also like in relation to that, that all sounds like you have to be prepared to fight back in case of, even if you register your design, and if you have like no money on lawyers or whatsoever, like I quite often heard that there's no even point even starting this kind of registration process if you have no possibility of fighting back. So these are like two questions. Thank you.
Thank you, Katarina. I think that we can both probably answer this one. I hear you, and as I think that we both said, there are different kind of options, and as I said, it's not a holy grail to get a design protection if it doesn't fit your strategy, if it doesn't fit your value position. And by saying that if you do not register or if you do not enforce your design, it doesn't mean that you don't value it, but the value just is different for the markets. And obviously, it's, as I said, it's a dog-eat-dog world out there. So in some cases, it's the hard truth that the money talks. So there are cases in which we see that if they're the designer or the design owner, even though that they have a registration, they are up against a big case and there will be several or severe legal fees, then you're right. We might say that there's no point in doing this because your business wouldn't or couldn't survive this. So I do understand your point of view, but still there are things that you can do. And I think that in your kind of industry, if I understood you correctly, it's more crafts, then I would tip my scale to more to the copyright side. I'm not sure if you agree with me, Andreea. And also to be kind of savvy about documentation, to document everything that you do, and also what would be the best advice? The best advice would also be to do contracts and be savvy with who you deal with whom you have business with. Okay, this begins to be a ramble, so I'm turning over to you, Andreea, if you have some wise words for Katerina.
Thank you. Just a few things to add in addition to what you have said. First of all, yes, if you end up in a conflict that's in a complex litigation, it might not be worthwhile if you work on a small budget. But then most complex litigation can be avoided if you have, if your work is original and if you are the one that protected first. So when we look at this, registration would involve smaller fees, a smaller investment on your part, but it might help you avoid conflicts, and it might help you sleep better at night knowing that your product was protected. And this protection, the registration can be, of course, also obtained for designs that pertain to crafts, as you said, the art crafts. So it's not limited to industrial designs. And yes, copyrights is an option. The Romanian authorities, for example, offers this service that is called the envelope with ideas. If somebody has an idea that is transposed in a work of art that can be printed and put on paper, like the image of something that you have created, a drawing or something, it can be filed for probative value before the office. And then it's not a registration per se, but it gives you a tool with which you can prove that you have created that particular work or that particular design at a specific moment in time. Now, maybe other offices throughout the EU have something similar. Don't forget about the SME fund. So if your budget is not enough, use the SME fund. It also grants a percentage, covers a percentage of the fees for registering for designs. So this might be something to look at. I had in my practice quite a lot of clients that took advantage of this for trademarks and designs. So don't forget about this.
Yeah, and just to add a few words to great answers there. As Andreea said, utilize the SME fund. You can use that money directly for expert fees. So maybe in your specific case, you can see if there's something now or maybe something kind of cooking up in the future that could be some specific feature that even if you do very individual work that varies case by case, maybe you have one handle or something that kind of always continues in each product. So kind of looking at it directly in your case, is there something still that could actually be protected with design? And then of course many times with more individual products and crafts, it does come down kind of more also on the brand side. So then the trademark becomes more important as well, so that your customers know that, okay, no two products are the same in your line or something like this. And then that in itself is kind of the value factor there. And then the brand value and the trademark kind of have more emphasis in that situation. Yes, do we have any more questions? If we don't have questions. Oh, okay, yes.
Yeah.
Yes.
Sorry. Hi, can you hear me?
Yes.
Thank you for a very valuable presentation. I have a few questions, like, for example, if I have to, as a designer, I have to attend some sort of project and I have to present my prototype and in the process, as that count as presenting the actual product, and am I losing my rights to, for example, to protect it? That would be the first one. And then the second one is there any kind of database where you can actually look into what works are protected? Yeah, thanks.
Yes, there are databases where you can look for designs. There are one from the EUIPO, which is very well functioning database, or at least there might be at least two. There's one for professional use and one for more designers use. I think that we can maybe send these links to the participants here today. And then there is also one that's very good from the World Intellectual Property Organization, Global Design Database and Hague Database, which refer to the International Design Protection System. In those databases, you can quite quickly find a lot of designs that have been protected. But obviously, they are only the designs that are protected, because obviously there are a lot of designs out there that might, like Andreea said before, enjoy the unregistered right protection, especially in the Europe. So 3 years from the publication against copying. And this is something that also to keep in mind when you go to the databases. But I think it's a very valuable kind of asset to have to go and see the databases. And also from the point of view that if yourself are considering filing a design application, go in and see, like, what do other designers do, what do other companies do, to get a kind of a sense that what kind of protection they are looking for, even before like contacting someone that can help you. Relating to the first question, my simple answer would be contracts. But if I understood you correctly, that you were asking that how in a process, if you're doing a freelance job for someone and you need to show the design interim during the process. Did I understood you correctly, or?
Yes,
Yes.
yes. For example, if you attend like some sort of, like, at the minute I'm attending like a project where I will have to go to different country and present my prototype, for example. And yeah, and does that count as showing the work, or?
Yes, definitely. It obviously depends on the scale of it, but I would say that it could be seen as at least novelty destroying. But at that time, depending on the design, obviously you could claim it as your copyright already. Use the copyright sign. That would be kind of the easiest thing to do, that everyone sees that this is mine, even though it's here, it's my copyright. And if you have the possibility and it's sensible to take a review before you go into these kind of showings, that you would consider actually registering one form of the design. Because obviously, as Andreea was also referring in her presentation, it's very important to, if you have different kind of designs, or if you're evolving a design or series of design, to think about that, whether it would be sensible to protect the variations. And I do understand the limitations of the resources, but at the same time, please use the fund because it's there for you. It's all of our money in the European Union, so use it. And I have to say that, as I said, I was 2.5 years in Norway. They don't have the same benefits. So you already have an upper hand towards the Norwegian designers. Go, go, go.
Just to add to what Katri said, I posted the links in the group chat, the link to the EUIPO design search and the link to the EUIPO global design database, just to give you a look and feel of what this database offer. You can go and play there and see what you find. You can research based on the type of product, for example, that you are in the field that you are in. And yeah, as Katri said, I would recommend registering before disclosing, even if you are just part of a pitch. But if that's not an option, signing an NDA maybe, or whenever you're showing your design accompanied by a disclaimer that clearly states that this is your work, that by showing this you are not transferring any rights, they are not allowed to, they have to respect your design, your authorship, and not use it in any way. Something like that, maybe they can sign something before the screening, or anything that you can agree upon in advance before disclosing your work.
Yes, thank you. Anybody else want to present their question? There are a couple of questions in the chat. Some of them we already went over. There's one question coming up now, just where to find court decisions when it comes to copyright, IP infringement, and plagiarism cases. Well, yes, there are different places. Kind of what kind of cases you're looking for, but when it comes to design, it's actually quite interesting to go through the appeal cases that EUIPO has, and then as they go forward. Yeah, I think we can also maybe post these sources into the chat for where to find these court databases. Were there other questions? Yes.
So follow-up question to my previous question. So with this kind of the difference between registered design or just your kind of ownership of you creating something, like for me this line is like really vague. Again, with industrial design all clear, or with like designing a logotype, logo or something like that. But with like all of the other things, again, coming closer to like design craft or like product design, which is not industrial but handmade, and also like if you register it, and then because it's always like, again, entitles some kind of variations or endless variations, and if somebody adds like minor change to like your idea and idea is not protected, what's like the practical or critical difference between registering or just relying on your authorship rights, and that's it?
If I may, I would say that first of all, the law doesn't differentiate between industrial design and design for other specific products that would not be considered industrial. So what we've said throughout our presentations applies to all works that can be protected as designs, as long as they fulfill the conditions that Katri had mentioned: novelty and individual character. So this is one thing. The other thing, yes, ideally you should register and protect design variations. You have the option of filing for a multiple design registration. So in the same application, you can include multiple designs pertaining to the same product. Now, if this is not an option, maybe the variations are too many, you don't want to take this route. The other scenario that you mentioned, where somebody adds a minor difference, yes, that minor difference, as long as it's minor, it will not forbid you from enforcing your design against what this person is doing. So as long as what they are creating does not sufficiently depart from what you have created and protected, then your protection also will be enforceable against their design. But this depends on a case-by-case basis. I know it's not an answer that you want to hear, but a design conflict is analyzed based on the external appearance of that design, the graphical representations that were protected, and they will be thoroughly analyzed in view of the overall elements, minor elements, or significant elements, and how they are similar or dissimilar to each other.
I wholeheartedly agree with the answer just given, and have to say that I think it's fairly common to say that, okay, design protection, you just need to change a bit and it doesn't infringe. That isn't true. But the thing is that unfortunately, as someone was asking for the links to the design decisions, there aren't that many decisions, because the unfortunate fact also is that sometimes it happens that the interests behind the designs and to taking to the actual court actions or taking the matter further, the interest behind the designs aren't that huge financially that would happen. So we don't have that much good case law. And based on that, I think that this false impression of designs not being good or not having effect has actually occurred. But I think that Andreea and I can agree on that we see a lot of things on our table that have been negotiated before going to court, because the interest has been small, but there has been register rights involved in those cases as well. So it's important to remember, even though I said that there can be nasty things that happen when things go badly wrong in the markets, and just to show you that these things are out there, and these are like valuable considerations to make when you consider whether or not to file your design. But still, I think that it's how to put it, if you don't have the resources, I think that's one of those key elements that you need to consider, unfortunately, even though there are support systems, luckily, in the European Union at least.
Yes, and I also want to encourage a little bit that, of course, sometimes these things can seem very unbalanced from the power point of view, but also here in Ornamo, we have seen a couple of member cases where they've kind of invested enough in the beginning to have good protection on their design, and we've kind of seen them go through the process of negotiating with possible infringers and coming to settlements without too big legal fees. So yeah, just adding to what was said previously, that only the tip of the iceberg is shown in these court cases. So most of these things are resolved somewhere outside of the public eye.
And also, Iiris, if I may add to this, that also referring to the EU cases and troubles with the administrative stuff, or even with some kind of dispute coming from your country, EUIPO has also a mediation center, and EUIPO has one. So there is kind of options out of courtroom as well, if the parties are willing to negotiate. That is the outset, obviously, but I'm thinking that they are at the outset, I think, more affordable, and you get a good advice and solid mediators. So That's also something to look into. And I think that if you have a good advisory or advisor, they would also suggest it to you when you come into this, end up into these troubles.
Yes, great point. There was one question, I'm trying to now just scroll through it, but it was about kind of the different variants, so that when you're in the process of making a product with a producer and you have a protected design, but then as the process continues and there are more and more variants done on the design, that what does the original design actually protect, and how do you deal with these different variants being done in the manufacturing phase? The person who asked the question can maybe clarify if they want. I'm just trying to find it, and
I already found it, actually. I think this one is for you, Andreea. You spoke about the variations of the designs.
Yes, and I think I remember mentioning that ideally we should protect variants if possible. Now, I guess it depends on how these variants are created. Are they created as part of a collaborative effort in which one or more designers come into play, and then this becomes a collective work, or is there something done within the execution of a manufacturing contract? And if this is the case, then you have to ensure that you have proper clauses there, that any amendments to your exclusive rights are done with your knowledge and with your agreement, and then any rights over these works are also born within your portfolio, let's say, assuming that the national legislation of that particular country also aligns to this. I think it can depend from one EU member state to another. So yes, there are different things to tackle in this scenario.
Great. I think in a few minutes we have to end this discussion here.
I found one question that I find very intriguing. Can we take this one?
Of course,
it comes from François Caspar. I think I badly pronounced it. I'm so sorry. My French is rubbish. So it's sometimes necessary to protect the design before communicating it to the client. In fact, sometimes happens that the client ceases the professional relationship and uses your creation without the designer's agreement. In this case, can we use IP, and how, or do you think that the legal provisions of business secrecy can help protect your design? I'm not sure if you're referring to trade secrets. Would you like to take this, Andreea, or Iiris even? I think that there are measures that you can take, but obviously the easiest one is if you have rights to the design. That's the first thing. But other than that, do you want to take this, Andreea, or Iiris? I think it's an interesting question, though.
Yeah, it's definitely interesting. It's definitely a scenario that feels very familiar. Let's say I've heard it from time to time from clients too. Well, if you didn't do a preemptive action of protecting your design before communicating it to the client, then it's very good to document the communication that occurred between you and the client, so that you can show, in case they do take your work without a proper retribution to you, then you can go to court and ask for compensation and ask that they stop using your work. And in order to do that, you have to prove that it was your creation, and you have to bring your correspondence and anything to show how your work was misappropriated. So you have to be diligent in ensuring that everything that transpires between you and this other party, your client, is properly documented. This would be my advice. Ideally, I think we also mentioned this before, you could sign an NDA or something prior to disclosing, stating that if they do not like what you have created, well, that you retain your exclusive rights over your creation, even if it was done, let's say, at their request. Now, this again may be different from one member state to another. So in our legislation, if something was created further to a lucrative mission contract, so if you have created something at the request of the party and you were paid for it, normally they have ownership over that creation. So it kind of depends on the relationship between you and this client. Maybe you sign an agreement before you start work and reveal the final product.
Yeah, similar comments from me as well, and it's good to remember that even though there are very many differences in IP legislation in different countries, we are actually talking about a relatively harmonized concepts around the world. But it's good to remember that, of course, there's other legislation that can help in this kind of situation. So kind of what I took from the question is that something that in Finland we have like misappropriation and business conduct type of situation that could apply. But now this does come to kind of more national legislation or regional legislation level. But it's good to remember that these tools work best as kind of like used together. So yeah, there can be many times other tools than just purely IP related tools that can help in this kind of situation where somebody clearly misuses someone else's property, whether that's intellectual or otherwise. Yes, but at this point, I think we are out of time, unfortunately, but also I'm very, very glad to see such lively discussion. And I very much welcome everybody to our next webinars that are all around the same general topic of designers' rights and IP rights and how to utilize them and enforce them. So absolutely warmly welcome you all to join us in October again. And just a quick reminder to answer the feedback survey that will be sent to your emails very, very soon after this webinar. But thank you, everybody. Thank you so much, Katri and Andreea, for taking this time, and everybody who took their time to participate in this webinar. Thank you.
Thank you very much also from my end.
Thank you so much. Have a nice evening. Bye.
Bye. Bye.
Bye-bye.
Thank you. Bye.